Hello, this is Karen, and welcome to this presentation of what is probate and do I need one? The super basics are that someone has died and there are some money or things in the deceased person's name, and you need a way to transfer the money and things to someone else, the heirs. To do this, sometimes, but not always, you need to be official. What does official mean? The most official way to do things when it comes to a deceased person's estate is opening a probate and getting what are called letters. Letters are official papers that say you're the person in charge. And the only way to get these letters is by opening a probate in a court. Common tasks involved in a probate include determining if there's a valid will, opening a court case, finding heirs and notifying them officially, paying the deceased person's debts, filing his or her tax returns, figuring out who gets what and how much, plus some more. Is probate that horrible? Is it to be avoided at all costs? This largely depends on what state you live in and how complicated your life is. Washington State has a very simplified and streamlined probate statute. Go online, you'll see top 5 states with the worst probate statutes. And that's probably where you'll find a lot of late night infomercials about the urgency of setting up a trust. Probate and setting up trusts both take some amount of time, money, and mind-numbing administration. However, you've got to balance the time and money you'll do upfront setting up and maintaining a trust versus the time and money your future executor will expend in a probate. You can't always know which is going to be less expensive. Well, who does all of this administration? If there's a valid will, the will names the person and the alternates. If there's no valid will, the laws of the state determine who has first priority, second, and so on and so forth. It's about what you'd expect, including spouses, parents, adult children, etc. If someone dies, do you have to open a probate? Not always. It will depend on what kind of assets the deceased person had, how much money is involved, and if there are other systems in place to transfer the assets in a different way other than probate. Let's talk about asset type first. This is just a starting point, and you really need to consult with a probate attorney to classify assets properly. However, common assets that transfer only with letters in probate court include things such as real property, that's houses and land that are only in the deceased person's name, financial accounts only in the deceased person's name, vehicles only in the deceased person's name. Are you starting to see a theme here? In contrast, common assets that can transfer to others outside of probate, meaning you don't need a probate, include things such as joint financial accounts, jointly titled real property, anything with a valid beneficiary designation form, such as life insurance, 401ks, and IRAs, which often have beneficiary designation forms. Now, if the form listed the beneficiary as my estate, then you might need to open a probate. How do you know which is which? You can test this by contacting the institution. Send them a certified death certificate and anything else they ask for. And if they start communicating with the beneficiaries on the form and ultimately turn the account proceeds to them, this means that you might not need to open a probate. If, on the other hand, they start asking for letters or saying they'll only speak with the executor, this is an indication that you need to open a probate. Next, probate may be avoided if there just isn't enough money involved. $100,000 is a decent chunk of change, but if you've got a straightforward situation with less than this amount, you could potentially use what's called the small estate affidavit process. There are a number of conditions such as 40 days passing, no one is open to probate, all debts are taken care of and paid, and you're the rightful successor, such as a surviving spouse or the only child of a single person. If so, you can potentially use this process and avoid probate. Probate is sometimes avoided as a result of careful planning in advance, or it's also common amongst long-time married persons. They have all joint accounts and the assets just pass automatically to the other joint holder. They're on the titles to everything. All beneficiary designation forms are filled out properly. And if it's a single person that died, they filled out pay on death or transfer on death, sometimes called POD or TOD forms, which functions similarly to beneficiary designation forms where the assets just pass to the persons listed on those forms. As always, consult with an attorney in your jurisdiction in advance to evaluate your alternatives, to simplify the job of transferring your remaining assets to your loved ones with as little confusion as possible. And if you're the survivor, consult with an attorney as soon as possible after the death of your loved one to ensure that your rights are being protected. Thank you for watching this presentation of What is Probate and Do I Need One?